The Tasmania Law Reform Institute considered the question of who is responsible for consenting to medical treatment to alter the sex of a person under 18. This is an issue that is not dealt with by the 2019 Tasmanian birth certificate reforms. It is a central principle of our legal and medical systems that patients should have bodily autonomy, a right to decide what happens to their bodies. Medical professionals are required to explain the risks and benefits of medical treatment. They need to be sure that a patient's decision to undertake treatment is informed and voluntary. But questions of informed consent can be complex when the patient is a child, especially for body-altering surgery. The law recognises that we all mature differently, and some young people can make informed decisions about their bodies at an earlier age than others. But the Institute heard that the current laws can create confusion and uncertainty. We heard stories of intersex adults who faced lifelong trauma as a result of surgery performed on them before they were old enough to consent. We also heard about transgender teens whose lives had been improved by access to medical treatment to affirm their gender. Parents and guardians also highlighted a great deal of confusion about role and responsibilities in such circumstances. They reported a lack of support or resources when making those decisions. Such factors can place a great deal of emotional pressure on them and their child. Some medical professionals have said that a lack of guidance on their responsibilities in respect of intersex and transgender children will place them in a vulnerable legal, ethical and professional position. In response to these issues, the Institute recommended new laws to deal specifically with young people's consent to medical treatment. These reforms would respect the autonomy and rights of young people and reduce confusion and uncertainty for guardians and medical professionals.